If you have an innovative idea, you need legal protection to prevent others from practicing your innovation. A patent grants you monopoly rights on your innovation for a specified period before the idea can be used without restriction by others. A patent adds value to your innovation. As the owner of the patent, you can practice your idea yourself, sell or license others to practice your idea. Not all ideas are patentable. An idea is patentable only if it is novel, non-obvious and has a utility value. It is not necessary that a patent should be novel in its entity. It can even be a new use of an existing product or process. By applying for a patent, the inventor describes an invention and claims monopoly in his name for a specified period. Acceptance of an application by a patent office with a filing date provides patent pending status to the application. Filing date grants priority to the inventor in case the same invention is claimed by another inventor before it is allowed. Patent applications can be filed with a national or regional patent office under national laws, or an international application can be filed with World Intellectual Property Organization, WIPO, under Patent Cooperation Treaty, PCT. An international application does not result in a patent, but it allows priority to the applicant in all states under PCT and may lead to patents in any of the member states.
There are 3 types of patents.
Utility patent.
Our utility patent covers proprietary rights on a novel technology, such as machines, mechanisms and chemical formulations. Our utility patent lasts for 20 years from the date of filing the application.
Design patent.
A design patent protects an original ornamental design. Design philosophy or functional characteristics of the design are not covered under a design patent. Life of a design patent is 14 years from the date of granting.
Plant patent.
A plant patent covers rights on discovery of new plant species and a method of plant propagation. A typical utility patent will have components such as an abstract, a prior art discussion, drawings, description and claims. Abstract will offer an overview of innovative features of the invention, while prior art discussion will narrate current state of the art. Drawings will illustrate various embodiments and innovative elements. Description explains the invention in detail, including functional specifications. By claims, as the name indicates, you are claiming title of all novel elements of your invention in your name.
Patent process.
Upon conceiving an idea, a comprehensive patent search is made to identify novelty and patentable subject matter of your invention. A patentable subject matter is an innovative element that is not covered by another patent or that is not on public domain. By performing a patent search, you not only identify the patentable subject matter of your invention, but possibly come across any closely related claims. Patent search will also provide you required prior art resources that you need to discuss in your application. Once patentable subject matter is identified, the inventor prepares drawings or sketches and notes on the idea in sufficient detail. A well-maintained inventor's journal will be helpful in drafting this. Patent application process is a task that requires specialized skills. Usually, an inventor has to work closely with the patent draftsman and a patent attorney. The patent draftsman prepares patent drawings and a patent attorney puts together the documents in formal order, writes the specification and claims and files the application. However, an inventor with reasonable language and drawing skills and basic understanding of legal terminology can also prepare and file a patent application himself. Sometimes patents filed by inventors are far superior to those filed by attorneys, since the inventor understands his invention better than anyone else. Given below is the step-by-step process of preparing and filing an application.
Prior art discussion.
In this part of the application, you will narrate current state of the art with reference to issued patents and published applications. You will possibly note down each referenced prior art in addressing the issues your invention is addressing. Thus you will prepare grounds for the examiner to agree to the relevance of your invention that you will be presenting in the forthcoming specification.
Brief description.
Here you will provide a short overview of the innovation with special emphasis to how your invention stands out of the crowd.
Drawings.
Under this section, you will illustrate various embodiments of the invention with proper figures. All innovative elements will clearly be shown and numbered.
Detailed description.
Here you will provide the specification of the invention in sufficient details. All innovative elements and their functional specifications should be clearly illustrated with reference to drawing numerals. Keep your language simple and straightforward, for one having reasonable skill in the art to understand and practice your innovation. In case you are claiming a method such as a chemical process, you may include few best mode examples so that the invention can be practiced the way you intend.
Claims.
This is the most important part of a patent application. By granting a patent on your application, the Patent Office is allowing your claims. Claims are usually drafted in legal language. You may be able to draft the claims even if you are not good at legal terminology. A simple, straightforward language that clearly conveys your message, leaving no room for confusion, is all that you need to draft your claims. Claims are usually well-structured phrases rather than complete sentences. Claims determine coverage of your invention against prior art and competitors. They are independent claims and dependent claims. Independent claims argue your invention in the broadest possible scope, while dependent claims define specific features of independent claims, and thus narrows the scope of your invention.
Abstract.
Although filed as the last part of the application, abstract appears on the first page of your allowed patent. Keep it as short as possible, yet informative to provide a snapshot of your whole innovation.
Filing the application.
There are two major types of patent applications, such as regular, non-provisional, patent application, PA, and provisional patent application, PA. A regular application has all necessary elements required to allow a patent. A provisional application requires only a general description and minimum one figure, if applicable, to understand the invention. Other elements, especially claims and abstract, are not required to file a provisional application. A provisional application has to be converted to a regular application within a specified period, 1 year in some patent offices. A provisional application allows priority to the inventor even before the invention is ready for regular patent application and with a lesser application fee. Web portals of major patent offices have electronic filing features. Once your patent application is ready, you can submit your application through electronic filing system of the web portal of the patent office and make electronic fee payment. Once electronic filing is complete, the website will generate an electronic acknowledgement with the filing number and date. This acknowledgement allows patent pending status to your application. You will get a written confirmation from the patent office usually within 1-2 months. Grant of a patent is preceded by a series communications between the patent examiner and you. You will have to defend your arguments well before the examiner on a number of office actions. Once the patent is issued, you have to maintain the patent live by making annual maintenance fees.